Article 3, Section 2. Common Interpretation by Judith Rinsnick and Kevin C. Walsh. Article 3 of the United States Constitution is devoted to the federal judicial branch. Thus, the first reminder is that this discussion is about the structure of the federal courts. States can independently create their own rules about their courts' jurisdiction, judicial selection, and the scope of judicial power. Article 3's first focus, Section 1, is on the existence of federal courts, and the Constitution specifies that the U.S. judicial system shall have one Supreme Court and then leaves to Congress the decision about when to ordain and establish the lower or inferior courts. Congress did so right away by creating 13 district courts and a smaller number of circuit courts in the first Judicial Act of 1789. Congress has increased the number of lower courts many times since. For example, in 1901, Congress has created lines for about 100 federal judges. By 2001, that number was up to 850. These federal judges obtain their office through provisions set forth in Article 2, due to the executive branch, which gives the President the power to nominate judges of the Supreme Court and lower courts, and the Senate the authority to devise and consent whether the Senate has an obligation to act on nominations in any particular way as being the subject of contemporary debate. Thus, individuals who become judges gain their office by virtue of the decisions of elected officials. But once the judges are appointed, the Constitution insulates their independence. Article 3, Section 1 provides all federal judges from losing their jobs from having their compensation be diminished. Thus, we speak of such judges as life-tenured, and some of them have sued and sometimes won when Congress has failed to provide them with cost of living increases or other salary benefits. To know what Article 3 does not provide: a guaranteed budget for the federal courts. Yet, as noted, Congress not only has increased the number of federal judges over time, but also in the 1960s added more personnel to the federal courts by creating the office of magistrates, now called magistrate judge. In the 1980s, the office of bankruptcy judge. These officials have dedicated courtrooms and do a great deal of judicial work. Their numbers double the size of lower federal court judicial personnel. Moreover, starting after the Civil War, Congress sought to create a federal presence by building impressive federal courthouses, often combined with the post offices. More than 500 federal courthouses now dot the landscape. In 1939, Congress chartered an administrative office of the United States that provides infrastructure support. And in 1968, the Federal Judicial Center dedicated to research and education. Thus, without constitutional guarantees of a budget with the potentially malleable constitutional text, Congress has more often been a supporter of the federal courts than an antagonist. Turns into some language that has occasioned debate. Article 3, Section 2 created a series of categories for cases or controversies to which the judicial power shall extend. Examples include all cases in law and equity arising under the Constitution, cases of animality and maritime jurisdiction, and controversies in which the parties come from different states, diversity, jurisdiction. Since the early days of the Supreme Court, judges have developed a body of law interpreting Article 3 and structural ideas of separation of powers to define what the Constitution does not, which are the words case and controversy. The court's jurisprudence limits the federal courts so they do not provide general advice to the other branches. Lawyers talk about this body of law as a focus on whether a claim is justifiable. Cases debate what kinds of injuries constitute harms. In today's language, injury in fact sufficiently linked to proposed defendants' actions to be appropriately redressed by courts. The Constitution also allocates authority between the Supreme Court and other courts, as Article 3 describes the Supreme Court as having original jurisdiction over certain kinds of cases, which means that cases can start, originate, and the Supreme Court, and appellate jurisdiction over others. A huge puzzle is how to read the part of Section 2 providing the Supreme Court shall have appellate jurisdiction both as to law and fact, which with such exceptions and under such regulations and the Congress shall make. This exceptions and the regulation clause has given rise to disputes over the extent of congressional control over the Supreme Court's appellate jurisdiction. That is, does it authorize Congress to eliminate the possibility of appellate review in the Supreme Court for entire categories of cases such as about school busing, abortion, same-sex marriage, religion? What authority might Congress have to craft rigorous limitations on the jurisdiction of federal trial courts? One account thinks of Article 3 as guaranteeing federal judicial authority, while another interpretation understands Article 3 to permit a great deal of congressional control over jurisdiction. Many scholars believe that the Constitution provides the most protection for the Supreme Court's original jurisdiction, which seems odd from our current perspective, given how small this aspect of the court's work can turn out to be. Other limits on congressional incursions on some views come from external sources, that is, other parts of the Constitution, such as the Fifth Amendment's protection of due process before deprivation for life, liberty, or property can occur, and the 14th Amendment's guarantee of equal protection of the laws. In addition, Article 3 also protects jury decision-making by requiring a jury trial in federal criminal prosecutions, with the trial to take place in the state where the criminals were committed. Moreover, in the less read part, Article 3, Section 3, the Constitution defines treason and insists that all convictions for treason not occur absent testimony from two witnesses or the confession in open court. Unlike several state constitutions of the same era, the federal Constitution does not include express commitments, echoing the Magna Carta that all persons have rights to remedies and that all courts be open. Yet case law and interpretation read Article 3 as protecting values of openness and judicial independence. And some read the Petition Clause of the First Amendment along with the due process clauses and protecting access to the federal courts. Within the structure marked out as Article 3, large swaths of extensive congressional regulation of a federal court's jurisdiction have existed without great controversy since the enactment of the Judiciary Act of 1789. Take diversity jurisdiction, which the Constitution provides without mentioning anything about how much is at stake. Since 1789, Congress has imposed a minimal amount in controversy, making some cases that fit the description parties from different states ineligible for federal jurisdiction. In fact, most of the law of federal court jurisdiction is statutory rather than constitutional in nature, and to determine the boundaries of federal court jurisdiction, one should begin by looking at the statutes enacted by Congress. Those statutes have to be placed into the context of Article 3, especially the 9 categories of cases to which judicial power shall extend. 5 ideas are relevant. The first is whether the jurisdiction is exclusive, meaning that cases can be filed only in federal courts, or whether jurisdiction is concurrent with the state courts. The second is what kind of cases fall within the description. The third is about whether Congress has to give jurisdiction or whether the Constitution automatically provides it, and or what kinds of limits Congress can impose. The fourth is whether once the federal courts have jurisdiction, then authority also provides them with the power to decide underlying obligations of the parties. The fifth question focuses on remedies. What are the powers of Congress to limit or expand the remedial authority of courts? Answers, whether right or wrong, are often blurry and shift over time. For example, while it seems straightforward to see that the federal courts have jurisdiction over cases arising under federal law, it turns out that deciding when a claim stems from federal right and when it depends on or turns on state law is complex. Moreover, even though a fundamental premise may be that any government's court shall be open to case arising under that government's law, in recent years the Supreme Court has held that even when arguing violations of federal antitrust or security statutes, plaintiffs can be precluded from coming to federal courts by virtue of another federal law, the Federal Arbitration Act, and forms given to employees and consumers to mandate the use of arbitration. Article 3 also specified that federal courts have jurisdiction over cases affecting ambassadors, other public ministers, and consuls. Again, the idea seems easy in terms of providing access by persons from other governments to a federal courts. But does that mean that if an ambassador seeks to divorce a spouse, a federal courts has jurisdiction? The Supreme Court has said not, and thus reads the language as not mandating that such cases can come only into a federal courts. Other illustrations of the challenges of a line drawing come from the category of admiralty, the maritime jurisdiction. These cases involve a distinct body of admiralty law and typically involve international or interstate relations in some way, making a federal forum more fitting than a state court. But what waterways count, and if a boat is docked and treated like a horse, do the federal courts have jurisdiction? Recent decisions have not been unanimous on this word ensues. In addition to the subject matter creating federal jurisdictions, the Constitution describes several categories for controversies identified by reference to the parties. For example, controversies to which the United States shall be a party and come to federal courts. But if a lawsuit is brought against an employee of the post office, is the United States a party? Likewise, while the Constitution specifies that a federal judicial power extends to controversies between two states, about if decision debate the question of whether when a state is a party and whether, for example, a regional body co-run by a few states can have access to federal courts by virtue of this provision. Article 3's extension of federal judicial power to controversies between a state and citizens of another state give rise to one of the Supreme Court's important early cases. In 1793, the Supreme Court held in Chisholm versus Georgia that the state could not be sued in the federal court. The Supreme Court, in that case, without its consent. But in 1795, the 11th Amendment was ratified at this the phrasing has produced yet more law debating federal court's jurisdiction than provision states that the judicial powers of the United States shall not be construed to extend to any suit in law or equity brought against the United States by citizens of another state or by citizens or subjects of any foreign state. A simple reading might suggest that the citizens of one state could sue their own state, but in 1890, the Supreme Court rejected a lawsuit with the same configuration and invoked the 11th Amendment in support of his holding. Noted another jurisdictional grant gives federal courts authority over private party diversity jurisdiction, controversies between citizens of different states. Standard count is that the concern was to insulate litigants from home state biases. The related concern for impartiality is also used to account for federal judicial power reaching controversies between citizens of the same state claiming lands under grants of different states. One might assume that once in federal courts, party rights will be decided based on federal formulated rules of decision, but in 1938, the Supreme Court famously held the Aryan Railroad Corporation was Tompkins that federal judges must generally apply state law instead. In sum, Article 3 has been enormously generated. The federal courts have, as Daniel Milner put it, been an important source of a common intellectual tradition, and since their inception, the federal courts have been the subject of intense interest and debate, with constitutional text as but one of many sources used to explain the myths and bounds.